So this is part two of this discussion. So just as a reminder to those of you who managed to tune into to part one of this, what we talked about there. I mean, I guess this is a brief intro to those of you who didn't manage to join that one. So last time we talked about what intellectual property is and what makes a discovery inventive. We're going to talk a bit more about that in a moment. And we began to detail the steps that you need to take as part of the process of doing your research. In other words, how to keep good records and the importance of keeping good records. And got to that point where we might be thinking that we have something patentable. So today is very much about patents and the whole process, what it feels like as a researcher to work through this process and where we end up with it at the end of that. So as always, use the chat window if you like to. I've got that open, so if you want to ask a question as we go, this is a workshop, not a seminar, so just type questions in there or thoughts or answers if I'm asking for questions to be answered. I noticed a couple of people like Jerry Swigers and Simon who are here, who probably know as much about patents as I do, so please jump in, guys, if you want to, and we'll see how we go. So this is kind of where we left it last time. So you think you have an invention. So that moment of discovery you've reached. The question is sort of what comes next, and the next is trying to patent it. Okay, so that's the focus today. The discovery is, so to speak, is behind us, but the paperwork around that is before us. And the first thing. The first step in this process is already yourself to understand the things that you need to satisfy, the criteria you need to satisfy in order for a patent to ultimately be patentable, for a patent to be granted, is the word that's used. And it comes down to these three key words. The last of them, be manufacturable, is fairly obvious. I've been involved in patent cases where somebody was effectively trying to patent a theory, so a mathematical theory of why certain kinds of ultrasound contrast agents worked. But as it wasn't itself manufacturable and the materials that were involved were all known, in the end it was a bit of a mess, so to speak. It wasn't readily patentable, and there was lots of court cases all around it. And basically the people who kind of made money out of this whole patent situation were usually the lawyers and people like me who were giving advice on the whole topic. The other two criteria here are much more important for us as scientists and researchers. So first of all, it's got to be novel. It's fairly obvious, isn't it? I mean, our research, ideally, whatever we do is novel in some way. The criterion for novelty in patenting is a bit more fierce. And as you'll see later, there can be a fair bit of argy-bargy between the inventors and the patent examiners as to whether it's novel or not. And the phrase that's often used is it needs to be novel compared to the prior art. Is it new? So the prior art issue there, prior art just means what is known before in the field, and then the prior art includes, this warning at the bottom of my slide here, the prior art includes anything that you've disclosed, and I'm going to come back to that in a minute, but anything that is known in the public area is part of the prior art, so to speak. So this becomes suddenly much more subtle, as you'll see in a moment, than you might think. Not obvious is another interesting criteria. So something can be novel. Think of a mousetrap of a traditional sort, but that it has maybe it's a copper spring rather than a stainless steel spring or a steel spring, something like that. At some level, it's novel to use a different metal for the spring, but it's certainly obvious to anybody skilled in the art of making springs or making mousetraps. Okay, so not obvious to somebody skilled in the art. Now, what does skilled in the art mean? Or sometimes the phrase is expanded to say to those of ordinary skill in the art. And you might ask, well, who are the people that are of ordinary skill in the materials or the electrochemistry or the biological sciences? Who are those people, right? It's certainly not the ordinary person in the street. So we're not talking, I mean, there's a lot of things that we do that wouldn't be obvious to somebody like that. So that's clearly not the reference group, so to speak. On the other extreme, in very, very detailed sort of narrow areas, people such as myself and Jerry, who have long, strong experience in certain areas, right? We are almost too expert in the field to be of ordinary skill in the art. So talking to all of you, you PhD researchers, you're it, basically. If it's something that's obvious to you lot, assuming that you've had appropriate undergraduate education, so you've got a basic professional qualification in the field, chemistry, materials, whatever. So if it's obvious to you, then it's obvious as a bystander. So if you say to yourself, having thought that you've done something that's novel, you might have to next say, well, is it actually rather obvious to change that element as a dopant, you know, from nitrogen to phosphorus, for example, one step down the periodic table? You know, the periodic table is the basis of a lot of chemical patterns, so it's going to be obvious to all chemists. So justifying that something is not obvious becomes quite a matter of discussion, even though it might be novel. But those 2 points, you've got to really sort of have some clarity in your own mind that those two are probably, you're probably over those 2 hurdles before you go too much further. Nonetheless, well, in fact, let me come back to this warning about prior art includes any material that you've disclosed. This can be messed up by you, by any of us very easily, if we're not careful about being confidential about our own research before it's patented. So what am I talking about? So you will basically put your own discovery into the public arena, into the prior art, so to speak, if you publicize it in detail. In any way, that means going to a conference and talking about it, presenting a poster, talking about it on Twitter, talking about it in any sort of area where it's remotely recorded or could be recorded, somebody with a camera taking pictures of your posters. I think there's a fair bit of that goes on. Just for the record, they get filed away and they get brought out later if there's of any value, shall we say. So there's people who do that. So confidentiality about your own research is an important point, and you have to think about this ahead of time. It's no good thinking about it later. How do you deal with this as a researcher before you ever get to the invention stage? Well, you have to decide carefully what is important to keep confidential yourself and amongst your community of collaborators. So there, in both the ACES community here, we have a collaboration agreement that's part of the head agreement between all the institutions, and everybody signs on to, all the researchers sign on to that confidentiality to ensure, if you like, that it's understood by everybody that this is a confidential discussion that we all have when we share our results at our meetings. And it's what we often talk about when we talk about an open meeting, which the February ACES meetings usually are, versus the closed meetings, which are our full center meetings and our weekly and monthly presentations, you see, because those are already confidential. You might ask to yourself, you might say to yourself, well, you know, I'm barely aware of this, and maybe I've heard something that one of the other guys, you know, one of the other nodes is talking about, and it'd be very easy for me just to go down to the pub on a Friday night and just sort of chat about this, you know, almost accidentally, right? And the point there is not so much that this is not something that absolutely stops that happening, but it does state for the record that the information is given and is noted as being confidential. So it's the intent, not the actual fact of the matter, that is important here. But if you don't take care of that, you and your boss and your institution don't take care of that intention to keep things confidential at the outset of any discussion or any release of the information beyond your own institution, basically, then you're in trouble because you just put it into the prior art. And it's one of the first questions that a patent attorney will usually ask you is, have you given this at any conferences? Have you presented any posters and so on, right? So think about that up front, and keep an eye on that, and you'll find that most of your bosses, your chief investigators, are fairly aware of the situation and will quickly decide what needs to be done, and with help from others in the institutions, if needed. Another way it can kind of slightly go wrong is if you're starting to talk to collaborators on email. You know, somebody, for example, I had an example of something that we did late last year. We were very excited about it. We wanted to involve an overseas collaborator on some DFT calculations of the matter. And I was very careful not to do other than warm him up, so to speak, get him interested, but I didn't really tell him what we'd done until the patent application had gone in. Once the patent application has gone in, so I haven't quite got to that point in time yet, but once it has gone in, then the problem is not so severe, right? Because the information is being recorded, that data is in the record, so to speak, and then you can be more open about your invention. But prior to that, you mustn't be. And one of the ways of handling it, let's say I had wanted to talk to this person, Lewis, about the detail. What I could have done is asked him and his institution to sign a non-disclosure agreement, right? That says, I'm about to tell you something that I'd like you to keep confidential because it is non-public information. Well, it's also called a confidentiality agreement. There's lots of names for these things. They're not usually very complicated, and many of us have been sort of the subject, if you like, of many of these in our research career. It's very, very normal. And it's usually the first step in any kind of collaborative relationship. So be ready for those, and be careful to ask about them if you do think that you're headed towards something that is patentable. Otherwise, you can blow it. Okay, let's assume we got over that issue. I have a tree muncher. Lauren, can you just tell me whether you're hearing the tree muncher in the background here badly?
It's fine for me.
All right.
You can hear your beautiful wind chimes every now and then, but it's not distracting.
All right. Well, no, as I say, somewhere a street or two away, there's a tree muncher gone into action. All right, I'll keep going. All right, so we've gotten to that point then of making our invention, and we think it's going to pass those three criteria. Okay. The first step then for you as inventors is usually to fill up a document that's called an invention disclosure. So most institutions and large companies will have a pro forma document that you fill up, just a few pages of information about the invention. And it's actually quite an important document because it puts a date, again, into a formal official file about it. I don't know what's Peter saying here. Pete's saying, generally speaking, individuals are not permitted to sign those. They need to be done by employee. Correct. That's an important point Pete's making there. Even though you are the person who's doing the disclosing and going to be the sort of dealing with the collaboration, it's the institutions that you form part of that are the ones that are actually doing the agreeing. So they have to sign it. You're not usually empowered to sign it. And that's an issue that you come across. There are plenty of times in certain places, where a little less formal, or where the laws are slightly different, that you can go to visit somewhere, and somebody will put in a non-disclosure agreement in front of you. You sit down to have a chat with somebody, and out comes a non-disclosure agreement, and they're asking you to sign it. Well, actually, you can't. Because it's not appropriate for you as an employer, this is the point Pete's making, to do so. So that effectively means that such things need to be organized in advance if you're going to have such conversations. Right. Right, where do we get to? So yeah, you're forming an invention disclosure filing it with your employer, usually a short document, says what the invention is, maybe a bit of detail. Often a draft paper forms the basis of what goes with this. So certainly that draft paper is going to be needed at some point or other in this next set of dot points. So if you started drafting up your results in the form of a paper, then get on with it, because because the various people along this journey will want to see it, and often our greatest motivation is to get that paper published, right? So, and all of these steps are, some of these steps are a barrier, if you like, to doing so, because you can't publish that paper. You maybe even can't submit it without all of this having been done. So the sooner you get on with write this paper up so that you can launch the rest of these steps, the better. Okay, so don't hold back on that. That's the point. So then what happens next is then it's usually in bigger institutions, there will be some patent attorney type people who will quickly then brief themselves on what it is that you think you've invented, start to review the situation, and assuming that that's what you might call a first step, sort of almost like a triage of whether you're on the right track or not with your ideas. They'll help you, of course, but they're going to be, since it's a bit of money about to be spent, they're going to be a little bit careful to make sure there isn't an obvious flaw, like did you announce this at last year's conference, for example. And then if it's all good, we get to the consult the patent attorney. So at this point, in most places, we'll call in a patent attorney from a local patent firm. Most institutions and big research organizations have got a number of firms that they work closely with in different areas, and the patent attorney. I'm not sure if I talked about this last time, but the patent attorneys are usually people of PhD level qualifications in relevant disciplines. So most of the people that I work with with our patents are PhD chemists. Sometimes they're Monash graduates, so they know us all quite well. And you're talking to experts. That's the point, and they will really dig into what you're doing and help you, often help you expand it a bit. So that will then become an intense, so this is where they'll want to see your draft paper to get the basic information, and in particular the experiments that you've done that represents the key examples. So there'll need to be a number of key examples that work really well and that you're able to put sufficient detail into that anybody in the future can reproduce. If they can't, your patent is null and void, right? But at the same time, the patent attorney is trying to get the bigger picture of what these examples might be representing, and helping you see what the bigger invention actually is. There's this sort of special situation that arises at this point in terms of what's obvious. At the point of invention, whatever is obvious to the inventor that's not obvious to everybody else is your invention. So subtle sentence. A very famous patent attorney in Melbourne once said to me many years ago, he said, Doug, this is like climbing a mountain where you can't quite see the top of the mountain because it's shrouded in clouds, but you climb through that mountain anyway. That's the research. And you finally get to the top where you suddenly get above the clouds. And then you can see all these other mountaintops from there. And he said, all those things that you can see are potentially part of your invention. And it's the patent attorney's job to help you understand that. So the patent attorney will suddenly be saying, well, could you, all that stuff about chloride salts, could you actually make them bromide and iodide salts as well? All of those things that are kind of partly obvious as chemists, the patent attorney will coach you in trying to sort of broaden, right? Now, often then the whole thing becomes quite broad, and at times you'll think, wow, is this really all going to fly? Well, then it becomes a little bit of a game of ambit, if you like. The first draft is a bit of an ambit. Sometimes you don't get the bigger, broader claims that you might try to get, but nonetheless, that's where it starts. So that's what I'm talking about here, is this drafting of what's called the provisional application. So the first formal document that is drafted about all of this by the patent attorney with a lot of help from you. Okay, and these can become very, very substantial documents, sometimes 100 pages of detail. And the structure of it is a little bit like the structure of an academic paper. There will be a bit of background and introduction where you and the patent attorney will try to identify key prior art, meaning key literature. So it's like the introduction to a paper. And then there'll be a description of the invention, which is a broad description of it in quite broad terms. Then sometimes more detail of that, getting a little bit more focused. No, I've got planes going over. Followed by these key examples that I talked about. So these must be very detailed, and you can't hold anything back. Your goal in those examples is to provide enough information that somebody could genuinely reproduce it one day. And then finally, the patent attorney will draft, this is like the conclusions of a paper, the patent attorney will draft a series of things called claims, which is effectively summarizing what we think the invention is in a hierarchical series of claims, literally claims, saying, we claim, in this invention, we claim the following in these short statements, getting more and more detailed as it gets into the detail, each one referring sometimes to the one before. And that hierarchical structure is designed to allow some of them to be struck out in the future. We'll come to that, but others will stand. See, so it's almost a game of making an ambit and seeing what will stick, so to speak. Okay, that provisional is filed in Australia. That's filed with the Australian Patent Office. It's an online form. That stage only costs a few $100s, but the patent attorney is likely to cost as much as $15,000. So that's why going to this step is something that the university will think a little bit about, because the budget for doing that in most cases isn't huge. Probably right now becomes quite small. Nonetheless, and then within the next 12 months, there's an opportunity to further detail the patent and add further examples, for example, or even sometimes add negative examples where you can illustrate the surprising nature of your invention by providing an example that doesn't work, right? So that helps to defeat the obviousness argument, because you can say, well, if it's obvious that this is true, then it was equally obvious that that's true, but that doesn't work, right? So my invention is not obvious for that reason. So negative examples are quite important. I've got a situation at the moment where a patent attorney has asked for some of those, and we're going to have to look back in our records to some of the experiments that didn't work. Okay, after 12 months, a full application is written. It may in fact be very similar to the original provisional, right? It may not be very different, but nonetheless, within 12 months, it has to be filed. What does Jens say? What if the university decides to not file an application on the invention? Is the inventor free to decide he wants to do this out of his own pocket? Jens, I might come back to that, because I've got a sort of slide on who owns it, if you like, later. So it's a good question, important question. Don't let me forget to answer that. Yeah, so after 12 months, a slightly updated document, you might call it, will get submitted. The 12 months deadline is shockingly inflexible. I don't even think COVID is going to be the basis for any kind of extensions, even though most of us have been locked out of the labs and whatnot for months, right? So I don't think I can think of a harder deadline in this world than that, right? At that point of filing the full detail, again, this is filed with the Australian Patent Office. Usually, you want more than just the Australian coverage of the patent. So the mechanism that's used is called the Patent Cooperation Treaty, so called PCT filing. So the thing that's filed is also called the PCT. And that allows you to specify a number of countries, usually the US, China, usually the usual lot, China, US, Europe as a whole, UK, I guess, will be separate soon, etc. Australia, India. And the purpose of that is to allow the next few steps to be done as a whole before it finally splits out into what's called national phases, where each country alone deals with your patent. And so there's an extra cost involved at the full application, the PCT application stage, and then when it goes a year or so later to the national phase, the costs start to mount substantially. But that stage will probably into $100,000 or more for the cost of pursuing this once it goes to multiple places. So let me keep going as I'll come back to that interesting discussion between Pete and Jens in a sec. All right, what happens next? So this document goes in the Australian case, it goes into a patent examiner in the US, in the Australian Patent Office in Canberra. And the examiner is usually, once again, one of us. This will be certainly a PhD level qualified person, usually, in a field very relevant, and who's also gone on and gotten patent attorney type qualifications as well. So that's a particular career path. And it's a little bit like judges and lawyers. The patent attorneys are sort of the lawyers involved. The patent examiners are the judges of this, right? So their job is to examine this, and they will in detail, in considerable detail. They spend days to weeks on any given application, and almost inevitably they'll send back a letter sometime later with a whole lot of objections, and there will be pretty short objections that say claim number 1 is refused on the basis of novelty according to document D1, and D1 will be some paper or patent that they dug up, which seems to them to make what you're claiming not obvious. Which is pretty deflating when that happens, when you see a whole set of claims just chipping away at your invention. But you get a chance to respond, and this with the help of the patent attorney. The patent attorney is usually the one that will draft a response with advice from you. So this objection and response can go back and forth for quite a while. Right, it becomes a bit of an arguing match between the inventors and the patent office. So that's why the et cetera there. But eventually, after sometimes there's a bit of fine tuning of the wording. Sometimes claims get deleted because they're not novel or they're obvious. But usually, well, not usually. If you've done well, your invention was well based in the first place, and the patent was well written, then it will be eventually granted. You'll be able at that point to call a patent pending, and it will be published. But applications also get published eventually, regardless of whether they're granted or not. This is important to know, by the European Patent Office. I think it's after 18 months. So you'll find in the literature a lot of WO numbers, which are published patent applications and are not necessarily granted. So it's important to understand whether you're looking at something that's being granted. But by being published, it's become part of the public, the prior art, the public domain information, and therefore nobody else can patent it at that point. So it's important, that part of the process is important to be aware of. All right, so there's the process more or less. Now what happens next? So you have a patent. What happens next? And the answer is a big yawning silence, because the patent itself is part of commercial law in most countries, and there's no patent police. There's nobody kind of watching over this situation that's going to sort of look after it for you, not at all. You, the owner of the patent, whoever that is, have to watch it, so to speak, watch for infringements of it. It's like owning a piece of land that you've issued a trespasser notice on. You've got to catch people in the act and then take them to the court, to civil court, to resolve issues. So patent itself doesn't actually achieve anything necessarily on its own, although it will warn off others by being published, will warn off others that you do have protected right on this. So it's that information, if you like, that in the end forms probably the most valuable part of the patent, because others will say, all right, well, I'm going to stay away from that, because if I do infringe, eventually they'll come after me. And yeah, so there's lots of stories I could tell you about that, but maybe I'll not digress too much, since there's a bit more to talk about here. But I've seen some very interesting examples of that in the past. Okay, coming back to this question of who owns it, right? So the previous point really makes the major point, which is that a patenting is expensive, and at the end of the day, you've really got to be able to protect it by taking action if need be. And that's not something that most of us individuals could do. It's not something that even the university is particularly interested in doing, because we just don't have the financial resources to do that. So ultimately, a patent is only of any strong value if a company is prepared to to take it up and ultimately defend it. And so the universities will often be looking to either license it or sell it to somebody relevant who will make some guarantees usually to the university that they will protect it and they will pursue development of it. So but coming back to the question that Jens and Pete were talking about, fundamentally, let's go right back to scratch. Fundamentally, the invention belongs to the inventor. It's your intellectual property. However, not for long is the point, not for long. You will have employers and most PhD students will, so employees and most PhD students will have signed an agreement, if you like, of some form that says that if you do invent something in your normal employ or your normal studies as part of the center or whatever you're doing, that you will give primary ownership of that to or in other words, you will assign it to the university. In our case, university. If you're CSIRO, if it's a biotech company, there's almost nobody that you can work for who's not going to want this as part of your employment contract. Look for it there. It's very normal. And what it boils down to is you're being paid to use what's in your skull to produce valuable stuff, and this is the valuable stuff. So it is pretty normal. However, there's two further points to that very important to know about. In the university system and in some companies, the inventors are rewarded, if you like, for this, incentivized, is a better way to put it. At Monash, and by statute, the university effectively splits it roughly 3 ways. So Central University takes 1/3 of any royalty or any income stream that flows back, 1/3 to the Central University. These are the people who've paid for the patenting and so on in the first place. 1/3 to the school and faculty who supported the research. So they paid for the labs and the water and the lights and so on, fair enough. And the remaining third goes to the inventors. And the inventors have to usually have decided or agreed at the point of filing the invention disclosure, roughly what the split is between the inventors. There's usually more than one of us, right? So at an early stage, by agreement, hopefully, and it's important that you do get happy with this. You don't want to get unhappy later on just because $1 gazillion appears. You want to be happy up front, and if not, say so. And then what will happen if you don't think that the split is right between, say, you and another PhD student? I've dealt with one of these in another group recently. Then a sort of an adjudicator will be brought in, usually from one of the patent attorney firms, and they will do a bit of a sort of forensic audit of the research that went into this and try and help resolve who really might have contributed more than somebody else. It's not a matter of eliminating anybody. It's usually just a matter of saying, well, who's done the majority share, that sort of thing. But the simplest approach to this, and it's one that often wins the day, is just all inventors are equal. And I think we talked last time about sometimes there are people who are inventors, who are authors on the paper because they've contributed something, but are not necessarily inventors because they didn't necessarily contribute to the genesis of the ideas. So then to finally come back to Jens's question, so that's all the sort of the normal process of an invention that is carried forward by the university. If it's not, if the university declines to say that they want to take it forward, then certainly at Monash and Pete, Jens and Pete, at Monash, then the inventors have got the right to take it up, and I've used that right once or twice to precipitate some action. It's a matter of, well, make your decision, please, because I'll take it up if you don't, and that's tough talk, but it sometimes galvanizes people to make a decision. But that may not be true of every university. Just going back to the point about inventor shares, that's not necessarily common in all institutions, right? So CSIRO would be the exact opposite, right? And the famous, as a CSIRO person, you're paid well for doing your job, and you don't expect any return if there is one. And the classic case there is the Cisco Systems, the wireless technology patent that paid out. Cisco paid CSIRO $250 million a few years back. The inventors, the original ones, got nothing from that. I don't think, that's all you can say. They just didn't get anything. And that's that. So whole different scenario. companies or many and varied small startup biotech type companies or tech companies will often incentivize their people with their inventors, just to kind of give them the best, that's the best enthusiasm for inventing things, but bigger companies might not. Let's look at the questions here. I think that's Pete's question. Simon says, you have something to impress investors with? Well, of course, yes, that's right. A very important point, Simon, actually. Let me expand on that. I mean, one of the values of a patent at all, even if it's still in process, is that if you're about to seek money for an investment in a company or a research project, ultimately you need to have it protected. Otherwise, you could suddenly find that some enormous corporation somewhere else in the world is suddenly doing what it is that you're doing, and your work is valueless because they've taken over. Not necessarily by copying you, but it might be by copying you. So the invention has what you might call a potential value in that is very important to most investors. So, Pete, yes, the splits are usually after some costs are recovered. There's a bit of detail there that I can't quite recall, but yeah, I've seen some costs go off the top, but not what you might call salary costs for the internal patent person, something. But external patent costs are often taken off the top. Where is it defined how university deals with it? In Deacon's policy, I could just find the procedure if the university wants to proceed. Not sure I can answer that question in detail, Jens. At Monash, it's often said it's in our Monash statute. So there's multiple layers of documents there but there should be an IP policy. We certainly have one of those at Monash that you could refer to, that should refer to other documents if need be. It's an IP policy document. Okay, moving on. I've talked, as we've been going through this, about various kinds of agreements that surround all of this legality, right? So we're getting deeper and deeper into the legalities here. And a lot of this stuff, if we've been previously working in the realms of the patent attorneys, remember these are people who are effectively like us, they've got our kind of qualifications, and they've just gone on and gotten some special qualifications to do with handling patents. This is the realm of the IP lawyers. These people will usually have law degrees, maybe science or engineering degrees as well. That's not uncommon, but they're primarily lawyers, right? That's their main job. What am I talking about? Well, we've already talked about the fact that the situation regarding who owns your inventions will already have been mentioned in your employment contract. Okay, and look out for that. And as I say, it's pretty normal, but if you're not comfortable with something, do ask about it. The thing that formally you will have to sign when you do have an invention and it's starting to go through the system, the university will ask you to sign something called, along with all the other inventors, called an assignment document. And it's basically the formal document that says, yes, I give all my rights as inventors to the university and all the rights to deal with it to the university. Pretty standard document. I think you're supposed to get $1 for it. Any legal contract needs to have things going back and forth, but a lot of people these days simply say, well, we paid you your salary last week, so you got it. Normal, don't feel uncomfortable about it. In setting up the right situation regarding generating intellectual property or using intellectual property in the research and development area, either through R&D agreements or collaboration agreements, like between all of the ACES partners or all of the ITTC partners, including the companies involved, there are collaboration agreements that basically say what the split will be even between the universities or between the universities and the partners. Okay, so these are all things that are carefully worked out in advance, although some of these agreements basically say, I always find this amusing, basically say, yeah, we agree to agree in the future. If this comes up, we will act in good faith to reach a reasonable agreement with the party, rather than trying to thrash it out beforehand. But nonetheless, it's all said in advance. And that's just a little lesson for us as individuals, that if we are dealing with somebody who's completely external to any of our communities, any of our bubbles, so to speak, like a collaborator halfway around the world that we're excited to collaborate with, if there's any chance of IP coming out of it, it's probably best to, at least in writing in an email, just get an understanding of what would happen. Okay. If you don't, it could get messy later. But you don't need to necessarily get the lawyers in on that necessarily. And then the last thing that you might come across, not necessarily be part of, but there would often be a licensing or some agreement to sell IP to an external company, and that you'll need to be aware of what the conditions are on that, because often there are conditions in those agreements that do, what should we say, place requirements on the inventors, because there's often trailing requirements on further IP that might be generated by the inventors in their ongoing research and development that the company wants access to, and fair enough. So often you'll be asked to sort of approve, or at least accept, as an employee, of course, that this is the case, that your work is going to be under some requirements. So all of those things we tend to have to deal with in our everyday research work. And that was all. So final discussion or further discussion about any of that? I think I've answered all the questions on the screen as we've gone, but shout up or type into the chat box.
Hi, Doug. My name is Daniela. So thanks for this webinar. It's actually very interesting.
Good.
Wanted to ask a question concerning disclosing things, for example, in conferences and things like that. So sometimes what I've seen, some people, they will file the provisional, my bad. So they will file the provisional and then go to conferences and start talking about this. But then let's say 12 months down the line, the university doesn't, file the non-provisional there. So then what happens in the situation?
Yeah, good question. So that's very, very important practically for all of us, because we're the ones that can get this all messed up. So the date of filing of the provisional is a very important day in your life, so to speak, right? Because on that day, your information has been recorded in the intellectual property sort of network of the world, as being noted, shall we say, right? Yeah. And your description of it. After that time, it is okay for you to disclose that information, because it has been previously recorded as, you've claimed it effectively previously as an inventive information. Okay, so that's why, the patent attorney will often ask you even beforehand, if you start, one of the first questions is, have you been to any conferences? No, I haven't. Are you going to any, is the next question, right? And if you're going to a conference, the patent attorney will get quite agitated about that. And I've had one talk I've had to pull out of in the last minute, because the patent just wasn't ready. And I didn't feel like kind of trying to cover over things on graphs and whatnot to make it, I feel that becomes a crappy talk. So I had to pull out of that talk. Better just to give it the chance to somebody else. So it's, as long as the patent is filed before you start disclosing it, you're good. Now, then your question went on and said, what happens if 12 months later the university says, we want to give up on this, right? I think that's what you're saying. Okay, that's the moment where your information is, yes, that's quite a critical moment. And there's a couple of things that come up here in time, that 12 months later. If a full specification is not filed and all the appropriate costs, fees and whatnot paid, then the provisional just disappears, because the provisional is never published. Only the PCT would be published. So from a provisional point of view, from a disclosure point of view, the provisional itself isn't the problem. It's the fact that you've disclosed the information to the world in your conference subsequently that is a problem. Okay, so it's important not to give up on that provisional if at all possible. Nonetheless, if the university has said with reasonable warning that it's not going to pursue it, this is where Jens's question becomes very interesting. In principle, at least certainly at Monash, you could say, you probably want your boss to support you. You could say, even as a student, you could say, I'd like to take up that, since you don't want it, I'd like to take it up, and then you'd have to arrange the financing to proceed at least to the next step, whatever that costs. Right? Might not be all that much money to even just to refile basically file the same document as the PCT. Okay. Yeah, sorry, somebody at the door, but I'll just ignore that for now. So have I fully answered that question? So there's something else I was going to say about that. The slightly awkward thing that I've seen come up, and this is sort of what you might call sort of slightly less than completely highly ethical and moral practice, not usually on behalf of a university, although the university can end up doing this just because of poor organization. But I've seen some companies manipulate a situation like this where they don't make a decision until the very last minute, and then basically sort of screw the negotiations to the last degree because the time is about to run out. You can see how that, so time tends to be on the side of whoever is providing the money, and it's not on your side in that case. So that's a very awkward moment. However, such as commercial life, so to speak.
Yeah. Sorry, can I just follow up a bit on that question?
Yes.
So for example, so basically in this situation, so around how much time you think like people will need to have the final answer saying, okay, are they gonna take it up or not? So is it like 6 months before the end, or?
I would say it would be reasonable to request an answer from if it was university within 3 months.
Okay. Yeah.
Within, as in 9 months after your original filing, within 3 months of the deadline, because that gives you 3 months to then do something about it.
Okay. Yeah.
Right? No, you might not get it. Universities can be slow to act, and they don't. And this situation doesn't come up very often. You see, so, but you could sort of put it fairly kind of. Are we talking theoretical here, or is this a real situation? But you could be fairly demanding about that in a reasonable way, and then start acting yourself to try to do something about it, in the expectation the university would give you a final go ahead.
Yeah. Thanks.
Yeah.
Thanks.
Hang on, where did we get to? Yes, Pete's point there, many academics think of a patent the same way as a publication, but it's far from it and will likely take many years of work to ensure it is granted. Quite right. And one of the sort of worst things about that is that it's many years of increasing costs to the university. So your enthusiasm for it doesn't want to wane, so to speak, $100,000 in, or else you'll become a very unpopular character around the place, you see. So it's not like just sort of bang in the provisional and forget about it, far from it. And you'll even be usually expected to be quite involved in any sort of licensing activity with the university. In other words, you're the expert, and you've got to explain what your patent's all about to anybody who's interested in taking it up, etc., etc. Colin says, what point does a patent invention simply become general knowledge where you don't have to pay to use it anymore, e.g. graphite anodes and batteries? Interesting question. There's a lifetime to any patent, which is of the order of 20 years. I think there's a little bit of difference in some different jurisdictions, different countries, depending on which date it stems from. Does it stem from when it's granted, as opposed to stem from the time period, or stem from the time when it was filed? But just say in round numbers, it's 20 years. And the whole generic drug industry is very much about recognizing when drug patents are about to come out of patent, and then as soon as they are, with full information provided, is available before, the drug companies are gearing up to sell. They know exactly how they're going to make their generic Panadol, for example, so that when the patents come out of currency, then they've got them on the market within months. Right? What can be done about that is that sort of supplementary patents are often filed in order to try to continue to protect something, right? Now, it's a bit, that becomes very specific. In the case of graphite anode and batteries, that's a very, very sort of generic idea. I wouldn't think there's much you can do about that other than try to patent a specific graphite plus something formulation, or the whole blend of materials that goes into goes into the coating, for example, column. So there might be subsequent patents that you might, if you were developing it, commercially developing a battery, you might find yourself actually infringing not the original one, but something subsequent. So, and conversely, if you're in the business of protecting your original invention, you're going to be trying to file patents like that along the way, so that the most practical part of it is filed, is protected some years down the track, so you get more years. For example, I think Panadol is still just Panadol, but there's so many different forms of aspirin around that were effectively new, as in rapid dissolve aspirin, for example, was a different formulation with probably with a bit of sodium bicarbonate in it or something like that to make it fizz a bit. That's a slightly new thing, and that was probably patented to give that company a bit of an angle on something different in aspirin. Yeah, Pete makes a good point. You've still got to pay for it. Every year you've got to pay for these patents, and if you don't, then they lapse, and then they're open. So companies that are wanting to keep an eye on patents being available will watch out for them lapsing, meaning not paid for. Genting says, university employee works on his or her hobby after hours and has some patent worth, oh, this is a classic one. Patent worth inventions, are these inventions belong to university employers? So, right, it comes down to that last sentence of yours, Genting. It's got to be pretty unrelated to what you're doing at work, right? So, if I'm, you guys sort of, most of you will know the sort of stuff that I work on, but if I go down to the yacht club on a Saturday and suddenly decide, okay, maybe if we structured that sale a little bit differently, and maybe it was a patentable invention of the materials that go into the sale, getting close at that point, then probably not, although I'm best to keep a good sort of ethical and moral standing for myself in my profession, and best to consult my employer, and I've had to do this once, and just get sort of not so much permission, but get agreement from them that they accept that this is not something that they want to stake any claim over, right? So the answer is, formally, if you can draw that dividing line between what you're talking about and what you do at work, and you can present it in a way that your employer says, yeah, I totally get that, so off you go, good luck, then great. If it's a bit marginal, you notice me saying, well, if maybe I'm talking about a new material, in that sale, it doesn't matter that it's a sale, it's about the new material. There could sort of just, link back to something that you're doing at work or that you had learned about at work, and then it gets tricky. So be careful about that one, because at the end of the day, there's an awful lot of patents that go in. There's something like 90% of them or something that are never worth anything. But your own professional reputation, right, is worth a lot of money to you. So you don't want to do something unwisely in that regard. So making sure your employer agrees with your assessment is probably the first thing you're going to do. And if they say, no, we do think that it's something we want to take an interest in, well, it's just saved you a lot of costs, right? Because it's going to cost you to do something about it separately. That help? Any other questions? No? Okay. All right, well, I hope that was generally helpful for you all. And as I say, this is very much about you understanding kind of how to operate within this sphere of intellectual property as researchers, and what to expect in the quite exciting activity of being part of a patent application going in. It's something that I think most of us could aspire to and would like to aspire to, and then just once in a while, but don't go making any plans around it. Just once in a while, some of these things actually return some money to the inventors. But those are in the vast majority. Most of the patent applications that go in ultimately don't reach commercial value from the point of view of the inventors. All right, everybody, I'll leave you to your day, and sort of recommend that you stay in touch with these ACES webinars and the ITTC webinars, because there's hopefully lots of useful stuff coming from lots of interesting people. Good. Nice to see you there, Simon, and others. And yeah, see you again. Cheers.